20 WPM English shorthand dictation. Be ready for it. Start. Para. The plaintiff and therefore the plaintiff became the owner in possession of the suit property. Full stop. The appellate court rejected the amendment on two grounds. Full stop. The first ground was that the earlier for also application for amendment was noticed and was moved, which was rejected, and therefore the second application was not maintainable. Full stop. The second ground was that if the amendment was allowed, the nature and basis of the claim of the plaintiff would change, and therefore the amendment would cause prejudice to the other side. Para. The submission of the learned counsel for the petitioner is that in so far as the first ground for rejecting the amendment application is concerned, the same is not legally sustainable because the rejection of the earlier amendment application was not on merits but was got dismissed as not pressed in as much as there were few technical errors, and accordingly a fresh application was not barred by principle of res judicata. The second submission of learned counsel for the petitioner is that since the trial court itself come to the conclusion that the trial land belongs to Tanku, no prejudice would be caused to the other side if the plaintiff accepts the title of Tanku and amends the plaint accordingly, and in case any case since the land does not belong to the defendant, therefore no prejudice would be caused on allowing of the amendment. Full stop. From the decisions noticed above, it is thus clear that pre-trial amendments which are to address the real controversy between the parties in the suit are not to be disallowed ordinarily unless it seriously prejudices the interest of the other side. Full stop. But in a case where trial has commenced and parties have laid their evidence at the time of allowing the amendment, the court, with reference to the facts and circumstances of each case, has to consider the question of prejudice caused to the other side in the event of amendment being allowed. Para. Now, coming to the submissions made by the learned counsel for the petitioner, in so far as the first submission of the learned counsel for the petitioner is concerned, that may have some substance, because if the earlier application for amendment was dismissed as not pressed, then it may not be a bar to fit filing a fresh application. Full stop. But in so far as the second submission is concerned, same cannot be accepted because the plaintiff had instituted the suit by claiming right over the land as sehan, which came to be vested. Full stop. Under section 9 of the UPZA and LR Act, whereas by amendment the petitioner has taken a complete change in his stand by claiming that the land was of Tanku, who had transferred possession and title of the same during his lifetime to the plaintiff. Full stop. The said plea cannot be permitted at this stage, particularly when the defendant had taken a stand in the written statement that earlier the land was in the possession of Tanku and thereafter it came in possession of the dependent. Full stop. Para. Section 13 in bracket 1 and in bracket 2 of the Surface Act 2002 quoted above proceeds on the basis that security interest needs to be enforced expeditiously without intervention of the court or any tribunal. Full stop. The legislative purpose for conferring the power on the secured creditor to enforce its security interest by taking recourse to section 13 in bracket 4 of the Surface Act 2002 without intervention of the court is to free the secured creditor of the impediment contained in section 69 of the Transfer of Property Act full stop under the provisions of the Surface Act 2002 a secured full stop